Mr. Christopher Mingledorf will be hosting our presentation for today. Mr. Mingledorf joined Moore Ingram Johnson Steele in 2005. He is a member of the firm's litigation department, and his practice areas include commercial litigation, construction litigation, business litigation, insurance defense litigation, and workers' compensation defense litigation. Chris received an undergraduate degree in finance and an undergraduate degree in international business from Florida State University. He received his Juris Doctor degree from Mercer University, where he is an active member of the Mercer University School of Law Moot Court. Mr. Mingledorf is licensed to practice in Georgia and South Carolina. He was admitted to practice in the Georgia State Court, Georgia Court of Appeals, Georgia Supreme Court, United States District Court, Northern District of Georgia, the 11th Circuit Court of Appeals, South Carolina State Courts, South Carolina Court of Appeals, and South Carolina Supreme Court. Mr. Mingledorf has represented clientele ranging from individuals to large multinational corporations. In 2011, 2012, and 2016, respectively, Mr. Mingledorf was nominated and selected by his peers in an annual nomination and polling process conducted by the Super Lawyers publication and Atlanta Magazine as a Super Lawyer Rising Star. Mr. Mingledorf lives in Charleston, South Carolina with his wife Emily and their two daughters Madison and Molly. In his spare time, Chris enjoys being on the water, camping, hiking, watching football, and relaxing with his family. Mr. Mingledorf, you can begin your presentation. Thank you.
Thank you, Montina, for that introduction. Today we're going to cover a few facts and questions that we get in construction litigation matters here in South Carolina. Today I'm going to talk about 5 points that we see here in South Carolina a lot. While there are certainly more than 5 points that anybody in the industry should keep in mind, these are 5 that come up on a routine or regular basis, and so I thought they'd be very helpful to cover so that people can have a good understanding of these 5 points. The first of the 5 points that we deal with in South Carolina in a construction litigation case is just identifying who are the necessary and important parties that need to be involved. As industry professionals know, whether you're dealing with residential construction or commercial construction, there are any number of material suppliers and subcontractors and laborers on a particular job over the course of the job. And so when a dispute arises later about the quality of construction, it's very rare that that dispute is limited to just one contractor or supplier. Most of the time, the work that's in question was touched by, accepted by, or maybe material was provided by more than one party. So when you get involved, depending on if you're the general contractor, subcontractor, or supplier, it's very important to identify the other parties that need to be involved. The first thing to do is if you're in the dispute and it hasn't quite yet risen to the level of a lawsuit, once you identify those parties, you need to put them on notice because like you, they too have an insurance carrier that probably does have some coverage for the dispute, and by putting the subcontractor or supplier on notice, they in turn will put their insurance carrier on notice, which is a very important aspect of the claim. You don't want to be late in your notice to a subcontractor, which might make them late in their notice to a carrier, and it might give that carrier a coverage or reservation of rights opportunity, which might come back to haunt you later in the claim. Now, if the lawsuit has already started and you identify these subcontractors or suppliers that need to be involved, there are ways to get them added as parties to the case. So again, I would make sure that I identify them, put them on notice, and then work to have them brought in as parties to the case. The other kind of party that you need to think about, especially in a commercial construction context, are design professionals. Here in South Carolina, particularly in the low country part of South Carolina where we have a lot of waterfront property, a lot of wind issues, a lot of saltwater corrosion issues, design professionals are used on almost every commercial construction job. And those design professionals can be everything from architects to engineers to building envelope or water intrusion consultants to even, believe it or not, here in Charleston, earthquake professionals who look at our fault lines and make sure that a building is built up to appropriate earthquake code. So depending on the nature of the construction dispute, design professionals may also need to be put on notice of a dispute and, where appropriate, brought in as a party to a claim. So again, that's something I would do in every case right out of the gate, is make sure you identify those parties and make sure they're on notice of what's going on. The second of the 5 points I want to talk to you today about is a right to cure notice that we have here in South Carolina. The right to cure notice is limited only to residential construction. So if you have a commercial construction dispute, right to cure statute does not apply. But in a residential construction case in South Carolina, you look at South Carolina Code 40-59-840, and that's the code section that provides the right to cure. What that code section says in short is, before bringing a lawsuit, a plaintiff must, at least 90 days before bringing that lawsuit, send written notice to the contractor or subcontractor of the construction defect and what has been going on with that construction defect. Now, part of the notice is for that contractor or subcontractor to use that 90 days to go try to fix the situation, thus avoiding litigation. As you can see, the South Carolina legislature put this code section in place in hopes that that 90-day notice and that right to cure on the contractor could avoid maybe some of your more frivolous or nominal type construction defect cases from actually getting into our court system and creating just more of a backlog. Now, there are cases that you see where the plaintiff has not provided that notice, but nonetheless has moved forward with filing their lawsuit. So if you're a defendant in one of those cases here in South Carolina, just like you're going to identify the other parties that need to be involved, make sure that notice was provided. Now, if the lawsuit's been filed, the notice was not provided, that is not, unfortunately, detrimental yet to the lawsuit. It doesn't entitle you to have the plaintiff's claim dismissed with prejudice. Instead, at most, at that point in the litigation, it would entitle you to have the litigation stayed for a period of 90 days so that the notice could, in fact, be provided by the plaintiff, and so that your client, that contractor or subcontractor, would have an opportunity to go cure the alleged defect. Now, if once you bring that up to the court, the plaintiff refuses to provide the notice or provide the contractor or subcontractor an opportunity to cure, then a court could certainly get to the level of dismissing the plaintiff's complaint, which from the defense side, of course, is a good result. The third thing that we're going to talk about today deals with warranties. South Carolina, like many states, has implied warranties that are built into construction jobs. A lot of times when you talk about warranties, the first thing you have to identify is this warranty created by contract or is it created by law? And contractual warranties in South Carolina are certainly alive and well. If an owner and a general contractor have a contract, and in that contract the general contractor, say, provides a 3-year warranty on certain issues or topics within the structure, then that's a contractual warranty and it will be upheld. Now, contract warranties aside, by operational law in South Carolina, there are implied warranties. A contractor has an implied warranty to perform his work in a careful, diligent, and workmanlike manner. That means, you're going to build something up to code. and industry standards, and it's going to be usable for the purpose for which it's fit. The other or second implied warranty put upon a contractor in South Carolina is the implied warranty of habitability, and that arises out of the sale of a home. So even though a builder may build a home, if he sells it to, say, he has a sales center type arm, and some of your bigger box builders here in South Carolina do that. That sales center, when they sell it to the homeowner, that warranty of habitability still is alive and passes, as well as the warranty for careful, diligent, and workmanlike performance by the contractor. So that's something to keep in mind. Almost every construction case brought by a plaintiff in South Carolina alleges violation of these warranties by the general contractor and the subcontractors. It is a real cause of action, something to be mindful of. In topic 1, I mentioned that design professionals are used a lot here in South Carolina under warranties. They too have warranties that are implied by law, and that is if they provide plans or specifications to a contractor, then they provide an implied warranty that those plans are accurate and that they're going to accomplish the purpose and view of those plans. And that can be important if you're representing or consulting a design professional, because a design professional may say, well, I provided plans and specs that are up to code and up to the contract that maybe I had with the owner or the general contractor. And that certainly is very good for the design professional, but that does not necessarily stop the discussion of potential exposure or liability for the design professional, because there is this additional implied warranty that South Carolina law puts on that design professional. So keep that in mind when you're dealing with construction-related disputes in South Carolina. The fourth topic I wanted to talk about or mention today is punitive damages. Almost every plaintiff that files a construction-related claim here in South Carolina alleges some aspect of punitive damages. The good news is the Supreme Court of South Carolina has routinely and on many occasions said that punitive damages in a construction case are only going to be considered when the conduct of the defendant is willful, wanton, or reckless. And that's a pretty high standard. In other words, if the defendant was only negligent, then that does not warrant punitive damages. Most of the time, while there might be an issue with the building or the home, and that may not be in dispute, the issue was created through negligence. It is a rare case and very difficult for a plaintiff to prove that a contractor or subcontractor was willful, wanton, or reckless as they were building the structure or carrying out their work of the improvement. So keep that in mind. Just because you see it, just because the plaintiff alleges it, does not mean it's going to be the case. The fifth thing for today's discussion are the statute of limitations and the statute of repose here in South Carolina. The statute of limitations in South Carolina for the construction of a home or something related to construction is 3 years. And the 3 years starts to run when the plaintiff either knew or should have known that there was a defect. Most of the time, I mentioned earlier that we have some special construction issues in the coastal and low country part of South Carolina due to the wind and water that we get here. So most of the time, a statute of limitations discussion turns on a water intrusion case. Maybe water has been getting into the structure for a couple of years, but was not readily apparent from the beginning. So even though it might have infiltrated the structure 6 or 7 years ago, the plaintiff is just now bringing the claim, and what you would have to analyze is when did they actually know water was coming in, or when should they have known water was coming in. Of course, a lot of times that's going to come down to the very specific facts of the case. Were there water stains on the wall? Were there puddles on the floor? Did a ceiling tile that was saturated with rainwater fall to the floor? Those sorts of things. So that's something to keep in mind with the statute of limitations. The statute of repose is a different time period in South Carolina, and that's 8 years. And what the statute of repose says is that 8 years after substantial completion of a structure, residential or commercial, that contractor is immune from liability and cannot be sued. Most of the time, the statute of repose does not come up because 8 years, of course, is a substantial period of time. When it is an issue in the case, from the defense side, you're going to look at substantial completion. And substantial completion is going to be the time that the 8 years starts to run. Fortunately, the statute here in South Carolina that sets forth the statute of repose, and that's Section 15.3.640, provides that the issuance of a certificate of occupancy by the appropriate county or city government authority is substantial completion. So if you know when the certificate of occupancy was issued and the plaintiff doesn't bring his lawsuit for more than 8 years, then right there in the beginning, you know you need to argue and raise your statute of repose defense. You might have a good one, and it needs to be investigated. Now, what are the plaintiff going to say in response, and what do they normally say? They say, well, the contractor was grossly negligent. And that's important because if the contractor was grossly negligent in constructing the home or the building, then the statute of repose does not apply. The gross negligence by a contractor is an exception to the statute of repose. So just like punitive damages, I see a lot, plaintiffs bring claims, and instead of just alleging that the contractor was negligent, they specifically allege the contractor was grossly negligent, and they're doing that because they're already trying to set up their exception to the statute of repose defense should you raise it. So just be aware of those issues. That is something that is factually intensive and unique to each case and should just be considered and analyzed in every construction case. Thank you for your time today. Those are, again, just 5 points that I thought were important for any industry professional that's handling a construction litigation dispute here in South Carolina. If anyone has any questions about the 5 topics today or any other topic related to construction litigation, I'd be happy to talk with you. It's easy to contact me one of 3 ways. Our website, which is mijscharleston.com. Our telephone number here is 843-302-0002, or my email address, which is ccmingledorf@mijs.com. I'd love to hear from you, and again, I look forward to fielding your questions or talking to you about your specific construction claim. Thank you.